Good evening. Today I'm going to look at a topic which is pretty important for all of us in the profession in terms of acting for and against former clients and the basis upon which it might be possible to restrain a solicitor who's acted in the past from acting against an old client. And the matter's been discussed in a great deal of detail by Justice Beach in the decision of Dealer Support Services and Motor Trades Association of Australia, 2014 Federal Court of Australia 1065, which is a decision handed down at the beginning of October. And the facts were pretty straightforward. There was a contested trademark dispute going on, and it was said that the solicitors who are acting for one side had previously, in a different light and different guise, different personnel, had actually obtained the trademark, and therefore there was an attempt to restrain the party from relying on the old solicitors. And paragraph 4, Justice Beach notes that there are notionally three potential bases by which the court's jurisdiction to restrain solicitors from acting against a former client or a new client from retraining such solicitors might be said to arise. What are they? First, that there's a real risk of the misuse of confidential information. Secondly, that there's a breach of a duty of loyalty, which has survived the termination of the prior retainer. And third, that the proper administration of justice requires that the solicitor should be prevented from acting to protect the integrity of the judicial process and the due administration of justice, including, of course, the appearance of justice. And the case is very interesting because for a long while in Victoria, following on from a decision in Spincode, a case called Spincode, there had been a suggestion that the second category, that there's some sort of duty of loyalty which survives the termination of the retainer, might also be relied on. But Justice Beach, in a very detailed analysis here, goes over all the cases and demonstrates pretty conclusively, in accordance with what I think has always been the New South Wales position, that that second heading, which relies on some breach of duty of loyalty, just doesn't exist. And so you're really thrown back on two possibilities. First of all, that there is likely to be some breach of confidential information, which has been derived from the first retainer and continues, or secondly, that the administration of justice requires that you be restrained because it doesn't look good if the laity, as it were, lay public, think that you can swap sides simply because someone is paying you some extra dough or for some other reason. Now, what are the bases? Well, he tells us in paragraph 34 that the first and usual basis for enjoining a solicitor from acting against a former client is that there's a real and sensible possibility of the misuse of confidential information. And that flows from a classic judgment of Lord Millett in Prince Geoffrey Bolkiar and KPMG affirm, 1999, 2 appeal cases 222. Classical case, you remember it all probably, we all remember it, wonderful facts. Prince Geoffrey is I think the younger brother of the Sultan of Brunei, and he's in charge of the Brunei fund of some sort, some huge oil fund, and there's some suspicion of peculation, money's gone missing from the fund. So he's charged by his brother, the Sultan, with investigating it, and he begins to investigate. KPMG are used, performing a large number of functions, some forensic and some accounting, and it then turns out that unfortunately it looks as if Prince Geoffrey himself was going to be the subject of investigation. KPMG naturally don't want to lose what must be a delicious piece of work, and so they put in place Chinese walls. They erect information barriers, and they appoint Team Blue or Team Orange, I can't remember the precise name, and they put on a completely new personnel, and they make sure that there's no possibility of a leak of information which has been given confidentially to the first team coming over to the second team. Is there an injunction? Well, that's a question. But the main basis of getting the injunction is that there's likely to be some leakage, there's likely to be some crossing of the Chinese wall or the information barrier. And as Justice Beach notes in paragraph 34, there are differences in emphasis in the authorities as to the degree of risk, the onus of proof, and what needs to be shown by the former client before any evidentiary onus shifts to show that there is no real risk. But in this particular case, the motor traders accepted that there was no such risk in this case, no possibility of risk, and that was because it was quite clear that no one who was involved in the first application which they'd made was continuing to be involved, and therefore no basis for restraining the other side from continuing to use the old solicitors. Now, the second basis is this notion of a duty of loyalty, and that's been kicking around since about 2001 from a case called Spincode. Spincode Proprietary Limited and Look Software. 2001, 4 Victorian reports, 501, and paragraphs 59 and 60 and following, Justice Brooking gave his view about questions of loyalty. But Justice Beach looks at it in great detail. We won't go into it, but paragraphs 40 and following, he concludes in summary that Spincode and the duty of loyalty doesn't really have any basis. No secure foundation in the authorities. Justice Brooking's analysis is obiter. Victorian case that followed Spincode not added to its conceptual foundations. Fourth, from New South Wales point of view, the cases haven't followed Spincode. Fifth, federal court cases have either not followed or been equivocal. There's no need for the second basis, and there are related conceptual problems with the basis. Well, it's a tour de force, if one may say so, with respect. Justice Beach looks at all the relevant dicta, all the cases in great detail, and concludes that there is unfortunately no basis in the authorities to support Justice Brooking's innovation, I suppose, if you like, in Spincode. And so that leaves the other general possibility that there may be a question of a breach of the public perception, if you like. New South Wales cases, for those watching us in New South Wales, never accepted Spincode. And a case I was in, actually, Beelan and Casey, classical case, Peter Young, Justice Young, CJ and Eck, Beelan and Casey, 2002, NSWSC 58, at paragraphs 15 to 21, he pretty much demolished it. And from that point forward, we had lots of cases in New South Wales, all of which are summarised at paragraph 65 in Justice Beach's judgment. Now, there are all sorts of conceptual problems involved in terms of looking at the basis of disloyalty, but that is not really likely to be argued in the future, I don't think. And there are various problems, of course, when looking at dimensions of loyalty, particularly in a context where you're looking at something that's going to occur after the actual retainer, the original retainer, has been terminated. And so, paragraph 89, he summarises things, and Justice Beach says, for all the above reasons, I do not accept the second basis for disqualification. If the theory that this second basis existed immediately prior to Spincode was true, I would have expected there to be numerous cases expounding and applying the principle prior to it and academic qualifications, and there is none. But there is a third basis, and that is the question of public perception in the administration of justice. And this was set out in a number of judgments, and Justice Beach discusses it as a basis for disqualification, paragraph 93 and following. And he says at 94, the test to be applied is whether a fair-minded, reasonably informed member of the public would conclude that the proper administration of justice requires that a solicitor be prevented from acting in the interest of the protection of the integrity of a judicial process and the appearance of justice. But you've got to weigh that, of course, because you've got to give due weight to the public interest in a client not being deprived of a solicitor of its choice. And the public interest is an important value, although it can be overridden with due cause. And the first and third bases are independent. So it's not enough to show that there's no leakage of confidential information. And we've got Justice Goldberg in a case called Photocure for that proposition. It's got an independent scope, and the third basis deals not just with private fiduciary relationships and inter partes fiduciary obligations, but rather the administration of justice, public interest, and the appearance of propriety of the office of the court. The third basis is not only justified, but its justification explains its additional scope. And nevertheless, because you're depriving someone of their choice of solicitor, it is an exceptional jurisdiction and to be exercised with appropriate caution. And he says with a certain irony that although the principles are clear enough, the application is another question. And they look at a number of factors here. They look at the fact that Ebsworth was acting simultaneously as agent for the Motor Traders Association in terms of being addressed for service of a trademark and acting for dealer support, but that overlap had ceased. The agency in acting by Ebsworth as the address for service didn't have a legal characterisation. Secondly, questions of fact and opinion are involved, but in terms of registration of trademarks, but there was only a very slight overlap between the two activities that were being carried on. And looking at the various facts, he concludes, paragraphs 103 and following, that there are powerful reasons pointing against disqualification on the third basis. He says, first of all, it's not irrelevant that there's no question of confidential information, no real risk of confidential information. So, although the two things are distinct and discrete, the first point is a very powerful one, and of course if you can show that, you're a walk-up start. Difficult to show though in this modern age if you've got some sort of effective information barrier in place. More relevantly, paragraph 105, the individual solicitors who are currently acting on the matter are quite different from those who previously acted for the Motor Traders Association, and they've never had any prior association with the old client. And thirdly, there had been a pretty long time period between utilising the services of Ebsworth and its own commercial decision in 2010 to retain a new solicitors for a range of work from that time. And it looks as if Minter Ellison came into the picture. So there was no actual conflict. The dispute was only a limited part of the proceeding, and as a matter of convenience or inconvenience, to restrain the dealer support team in terms of the trademark from engaging Ebsworth would cause unnecessary cost and inconvenience. It was said there'd be some sort of forensic advantage gained by letting them continue to act. Submission had no substance. It couldn't really be said that there were any issues in relation to that. So an interesting case, and shows I guess a very detailed analysis, as I've said, of a second point. Spincode now appears to be a dead letter. We don't need to worry about Spincode. You've got two main bases for complaint. First and foremost, if you can show us some breach of confidential information, then you'll be able to restrain the older solicitor. And secondly, but perhaps more problematically, you will be able to do so if you can show that there's likely to be some public misperception in terms of the way justice is being administered. And that might flow from the fact that old solicitors are very closely associated with the new matter, but you've simply jumped ship. We've got Canadian authority I won't discuss tonight in the Supreme Court, where you simply sack the old client and start up with a new one because they're offering you more money. A classic case in the Supreme Court of Canada, where they sacked the old client because they were suddenly offered a huge class action. I guess in Australia that would also apply. So we'll look at perhaps look at that case in another video, but have a look at Dealer Support Services, Motor Traders Association, 2014 FCA 1065, Justice Beecher tour de force, and for what it was worth, Spincode, I guess even in Victoria now, is no longer of any authority.